Hi, I'm Andrew Meinzer of Meinzer Law Firm PC. Today I'm going to continue to talk with you about capacity and incapacity. Specifically, we'll discuss the capacity necessary to sign trusts, wills, powers of attorney for financial management or asset management, and powers of attorney for healthcare or advanced healthcare directives. This is the second video of a three-part video series. In the first video, we discussed the lack of capacity for managing someone else's affairs through a conservatorship court proceeding or through her trust and powers of attorney. A trust, power of attorney for financial management or asset management, and power of attorney for healthcare or advanced healthcare directive ensure that things go smoothly for you if you become incapacitated in the future. A trust and will also typically provide for distribution of your assets after your death. Naturally, you need to have sufficient capacity to sign these documents. So let's discuss the level of capacity that you must have to be able to sign each of these types of documents and have those documents be enforceable. We'll start with the trust. There's no California statute that expressly states a level of capacity required for signing a valid trust except for one, and that statute involves other issues, so we'll discuss that statute in the next video. Further, a trust is a type of contract, and it also is similar to a will because both documents typically provide for distributing assets after death. California law states the required levels of capacity for contracts and wills, as I'll discuss in a moment. To sign a valid trust, you must satisfy the legal requirements for both contracts and wills. Turning to the will next, to have capacity to sign a valid and enforceable will, you must understand the nature of the testamentary act. That means you understand that signing a will directs where your assets will go at your death. You also must understand and recollect the nature and situation of your property. And you must remember and understand your relations to living descendants, spouse, and parents, and those people whose interests are affected by the will. Power of attorney for financial management or asset management. You may sign this document if you have the capacity to contract. All adults are capable of contracting unless of unsound mind or deprived of civil rights, which essentially means in prison. There's a rebuttable presumption that an individual is of unsound mind if the person is substantially unable to manage his own financial resources or resist fraud or undue influence. And this is not to be proven solely by isolated incidents of negligence or improvidence. This is the definition of incapacity for creating a California conservatorship of the estate for someone, as you may recognize from our prior video. So, if you are the subject of a conservatorship of your estate, then you presumably are of unsound mind. Fourth, power of attorney for healthcare or advanced healthcare directive. To have capacity to execute a valid and enforceable power of attorney for healthcare or advanced healthcare directive, you must appear to be of sound mind and under no duress, fraud, or undue influence. Also, there is a rebuttable presumption that an individual has capacity, an adult individual has capacity to make healthcare decisions, give and revoke advanced healthcare directives, and designate and disqualify surrogates. Surrogates are the designated decision makers in this context. But there's more to the story, as we'll find out in the third and final video in this three-part video series. The next video will discuss some capacity rules that overlay all the rules that we discussed in this video and the first video. Making a mistake assessing a person's capacity regarding trust and estate plan documents could be catastrophic. If a person lacking capacity signs a trust or other estate plan documents, someone may be able to invalidate those documents after her death or when those documents are needed through a court litigation. Hiring an attorney experienced with trusts can help avoid a lot of this. In addition, the advice and guidance of an attorney experienced with trusts is invaluable for attaining your goals in these types of cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients achieve their goals in trust cases. Again, I'm Andrew Meinzer of Meinzer Law Firm PC. If you know that you need our help, or even if you just have a question, please contact us and let us take care of you.